residential condo multifamily lease. The very beginning of this lease has a non-lawyer's disclosure. We're going to run through this really quickly so you can understand the full extent of what is needed to be done in regards to this particular part of the form. It says instructions to the licensee. Before you begin to complete the next form, you must give the non-lawyer disclosure to the landlord or the tenant for whom you are filling in the blanks. If you are filling in the blanks for the landlord and tenant, complete 2 non-lawyer disclosures and give 1 to each. So if you are on the landlord side and you happen to also represent the tenant as well, you're going to need 2 of these documents to have them sign, that the landlord sign one and the tenant to sign another one. They do not sign the same form. So then it says section 1 here. The next 5 sections, you're going to fill in your name in all of these 5 spots. And what does it mean to have your name filled in all of these 5 spots? It says here that Michelle Richardson told me that he or she is a non-lawyer and may not give legal advice, cannot tell me what my rights or remedies are, and cannot tell me how to testify in court, and cannot represent me in court. It also states Rule 10-2.1b of the rules regulating the Florida Bar defines a paralegal as a person who works under the supervision of a member of the Florida Bar and who performs specifically delegated substantive legal work for which a member of the Florida Bar is responsible. So this is stating that you are not a paralegal. This 3rd section here, Michelle told me that he or she may only type the factual information providing by me in writing into the blanks onto the form. Except when typing, Michelle may not tell me what to put in the form and may not complete the form for me. However, if using a form approved by the Supreme Court of Florida, Michelle may ask me factual questions to fill in the blanks of the form and may also tell me how to file the form. What all of that means is that if you have another lease that a landlord likes to provide to that tenant, it means that you cannot fill that out. That landlord has to fill that information out and then have the, you can send it to the tenant to sign. When it comes to the Florida Bar and the Supreme Court forms, which is this form here and the lease that we're going to review, it means that you are allowed to fill in only the blanks. You cannot provide legal information, and you cannot interpret what the lease states. If they do not understand the lease, then they have to seek legal counsel. So you'll notice down below right here where it says the landlord or the tenant, it says I can read English, I cannot read English, and then it tells them to fill in their name and the language that they speak. You will notice here that you can't fill in any blanks or check any of this off. They do not allow you to fill in the blanks. They want the actual particular landlord or the tenant that is filling this out to check those boxes off, to fill in their name and put in the language and sign the form themselves. This is not a part of the contract that you guys are allowed to fill in whatsoever, so make note of that. If you're using Form Simplicity, Transaction Desk, or so forth, they may have to print this form off, this particular page off, and actually fill in that information. And then on the bottom left, it's going to say licensee's signature. So you will sign the bottom of the page there. Well, let's get into the lease. This is the residential lease for apartment or unit in multifamily rental housing other than a duplex. So it includes a mobile home, a condo, a co-op for the term to exceed 1 year. You cannot fill these leases out for 2 years or longer. It has to be for a 12-month period or less. This lease cannot be used for any commercial, agriculture, or other residential properties 5 units or larger. So basically it says, read through it all. You have all the spaces that you can fill in. But right here, it states here, no changes or additions to this form may be made unless a lawyer is consulted. So basically, you cannot cross off information and have somebody initial it. You cannot add anything into this lease. An attorney has to fill that information in or create additional clauses or anything like that. Or if you have a landlord that wants information to be placed in there, they can fill that information into that lease. But you as as a real estate agent cannot change this lease up whatsoever. So we'll kind of go into how that works. So here you would say, all right, this is a 12-month lease. It's going to start September 1st, 2020, and it's going to end August 31st, 2020. You're going to put in the seller's name or the landlord's name, Mr. Landlord, and you're going to put in the person, Mr. and Mrs. Tenant, or whoever's renting. Down below here in the lease, the owner, whether one or more of the property, is called a landlord. All persons to whom the property is leased are called the tenant. Very self-explanatory. Now here is where you have to provide the landlord's email address, the landlord's telephone number, so that if the tenant needs to get a hold of the landlord, they know they have their number written on the lease. And also you want to put the tenant's email address and phone number in here as well, so they can the landlord can reach the tenant. This is where you would put the building number, the unit number, the street address, the condo name, the city, and the zip code. So you see it's all spaced out here. They didn't just put it all on one line. And then it says here, together with the following furniture and appliances. So if there's a fridge, stove, microwave, dishwasher, washer and dryer, you would put that information in there. If this is a furnished unit, or partially furnished, you can start saying, okay, well, table, chairs, couch, 30 pieces of forks and knives, you know, information like that. Now, if it gets really tedious in regards to when you get down to forks and knives or something like that, and there's a long laundry list of stuff, you're going to just type in here, see Exhibit A, and then draw up an addendum where it has all the itemized things that are coming with that lease. But you want to make sure that you have all of that information in there to know that what is staying in that unit. So here it says list all the furniture and appliances. Now, if there's absolutely none in there, then you must type none. So that means there would be absolutely no appliances, no furniture of any type. So in most cases, when you're leasing, you're definitely going to want to put in, you know, the fridge, stove, etc. The landlord and tenant grants the tenant the permission to, you know, to all of the common areas. Rents, payments, and charges. Tenant shall pay the rent in the amount of. This is going to be your monthly rent amount. So if it was $1,200 on the first day of each month. And then down here, if this is an annual lease, down here states that there is taxes and stuff like that. This lease can also be used for a shorter term period. Remember, anything under 6 months, most likely there'll be taxes in regards to that. So down here, it says here, tenant shall pay with each rent installment all taxes imposed on the rent by taxing authorities. So the amount of taxes payable on the beginning date of the lease is, if you had a lease for 5 months, then you would, you know, add $1,200 times whatever the taxes are times 5 months, and you get the tax amount there. So say it was like $400 or something. I have some, let's do the math here. $432. Then here you would put the annual of everything that they would pay. So for all intents purposes for doing the math, this would be $1,200, $432, and I did it on an annual. This would actually be half of that if it was like a 6-month lease, but you get the point. This is an annual amount here. Down below here, unless this box is checked, the lease payments must be paid in advance beginning on X amount day. So if you have advance rents or anything like that and you want them to pay in advance, you would put that advance date there. If the tenancy starts on a day other than the first of the month or week as designated above, the rent should be prorated in the amount of. Say for example that you had somebody that wanted to move in on August 25th instead of the 1st. And so we're going to do the month, the rent amount. We're going to prorate the month of that rent, and that would be $280. And we're going to want them to pay that when you're paying everything else. If you're doing it for September 1st for the move-in date, then you would have September 1st written there. So how did I get the $280? Well, the rent is prorated based off a 30-day month. So August has 31 days in the month. However, this lease is always calculated by 30 days. So you take that $1,200, you divide it by 30 days, times it by the amount of days here, which is 7 days. That's how you get the $280. Now, the section 5 here, deposits, advance rent, and late charges. In addition to the lease payments described above, the $1,200 or advanced rents, tenants shall pay the following. So if there's a security deposit of $1,200, you would put $1,200. If there was the advanced amount that they're going to be paying, an additional $280, they'll pay $280. If there's a pet deposit, $500 or whatever the number is there. If there's any late charges in the amount of, and let's just say $75 for each lease payment made more than 5 days, 7 days, whatever you guys want, 3 days. You could do 3 days because you could do the 3-day notice for evictions if that's something you want to coordinate together. So this is for the August, sorry, let me go back here 1 second. August 2020. So the advanced rent that we calculated up here would be the $200 for the periods of for August 25th to 31st. Forgot to fill that in, sorry. Pet deposit, $500 on a late charge. Now, before I start in with the bad checks and the remainder amount here, you're going to notice on this lease where it states the security deposit of $1,200 to be paid upon the signing of the lease. To be paid upon the signing of the lease. To be paid upon the signing of the lease. The lease supersedes the contract to lease. So basically, when the landlord and the tenant sign a contract to lease, the contract to lease states that the landlord can dictate where that deposit is. So if you're on the tenant side and you put the money in an escrow account held with location, and the landlord now, once the lease is signed, has the right to state where that money goes. So if they want it transferred automatically once the lease is signed to go into their security deposit account or the account that they have for this property, they have the right to transfer those funds. So if you put those funds into our escrow account, the contract to lease is signed, the lease is signed, the landlord dictates where they want to move it, you have to move that money because the landlord has the right to do so. So just notice that it's everything here says upon the signing of the lease for security deposits, advanced rents, pet deposits, and pet deposits. So just be very cautious of coordinating that along with the contract to lease to make sure that you are fully aware and educating your customers. So for the bad check fee in the amount of, it states here not to exceed $20 or 5% of the lease payment, whichever is greater. So right now we have a $1,200 a month payment. 5% of that is actually $60. So we are allowed to charge over the $20. We can charge up to $60 for a bad check fee. So we'll put $60 there for the bad check fee. Another thing that I've seen people put here is if you want to require renter's insurance to be provided to landlord by August 25th, because 2020. So you could ask them to get renter's insurance and to provide information to the landlord by August 25th. If there's something else that you want to do as well, you could put it there. You could put here renter to pay for car decal, fob, etc. Anything you want, basically, you could put there. That's just an idea. Security deposits and advanced rent. These all have to, it says if tenant has paid a security deposit or advanced rent, the following provisions apply. Because if you see here, these all say upon the signing of the lease. If they haven't taken possession of the unit yet, that means the landlord will have $1,480 sitting in an account. It's got to, the landlord has to specify where that money is. It has to be in the state of Florida. They can't transfer those funds to any other state. The money has to be stuck in a Florida bank account. So it says landlord shall hold the money in a separate interest-bearing or non-interest-bearing account in Florida banking institution for the benefit of the tenant. So, or if they're going to put it in an interest-bearing, you know, it goes on in here. I'm not going to go into it, but if the landlord rents 5 or more dwelling or units, then within 30 days of the tenant's payment of the advanced rent or security deposit, landlord must notify the tenant. That's if they're renting in 5 units or more. If it's a house or a condo or something like that, they don't have to do such a thing. Notices. If you are wanting the notice of when the tenant wants to move out, or notice for anything, termites, whatever the issue is, you can put your name here. Is the landlord's agent. All notices to landlord and lease payments must be sent to landlord's agent at, and you will provide the address of where they're supposed to send these notices in. If you're not a property manager or you don't do anything with property management, I would highly recommend not putting your information there. I would just let them deal with the landlord on how they want to work with all of that, because you no longer have any obligations once the lease is signed and the tenant is moved in to have to do anything else after the fact. So that basically terminates everything. So terminates your agreement with the landlord to help them find a place, is what I should say. Unless landlord gives written notice of change, landlord's agent may perform inspections on behalf of a landlord. This is something you don't want to take place with. Leave this alone. Don't put your information in there. Use of the premises. Tenant shall use the premises only for residential purposes. Tenant shall obey and require anyone on the premise to obey all laws and restrictions. So they're just giving permission to use the pool and all the other amenities. Down here, unless the box is checked, landlord may adopt, modify, or repeal rules and regulations for the use of common areas and conduct on the premises during the lease term. Usually this is unchecked. The landlord, unless he's on the association and cares truly about the rules and regulations and stuff, usually that box is unchecked. Occasional overnight guests are permitted. An occasional overnight guest is one who does not stay more than, depends on what the association allows, probably 7 nights in any calendar month. If left blank, you can leave it in 7. It has it built in there. Landlord's written approval is required to allow anyone else to occupy the premises. So you always want to check with the landlord, or explain to them to check with the landlord if anybody else is going to stay in that unit, so there's no trouble caused or hurt feelings in regards to somebody that wants to stay there 8 or 9 days. So unless this box is checked, or a pet deposit has been paid. Tenant may not keep or allow pets on the or animals on the premises without landlord approval. So it says here, tenant may not keep or allow pets. So if they're babysitting a pet or something like that, they just be cautious of what the rules are for them. Unless this box is checked, no smoking is permitted. Tenant shall not keep any dangerous or flammable items on the property. Tenant shall not create any environmental hazards on the premises. Tenant shall not destroy, deface, damage, impair, or remove any part of the premises belonging to the landlord, nor permit any person to do so. This is why it's very important that if you have washers and dryers and appliances and maybe some furniture, that you want to make sure that you're putting it on the lease. So if they do damage anything, that if you ever had to take them to court or whatever, you showed proof and they acknowledged those items were in that home. Also, pictures is very important too. If you have stuff like that, keep pictures that are time stamped to the date that the appliances and stuff were in there, maybe the date of move-in. You could do something like that. Tenant may not make any alterations or improvements to the premises without first obtaining the landlord's written consent to the alteration or improvement. However, unless this box is checked, tenant may hang pictures and install window treatments in the premises without landlord's consent. So provide tenants remove all such items before the end of the lease term and repairs all damages resulting from the removal. So if they put up pictures, blinds themselves, and they remove them, they must repair the damages and the holes and stuff like that. That's what it's stating here. Tenant must act and require all other persons on the premises to act in a manner that does not unreasonably disturb any neighbors or constitute a breach of the peace. So it has a lot of information in here in regards to tenants, you know, keeping the peace. Maintenance, very important here. Landlord and tenant agree that the maintenance of the premises must be performed by the person indicated below. Sorry about that, I'm still working. Landlord's required maintenance. The landlord will comply with applicable building, housing, and health codes relating to the premises. If there is no applicable building, housing, or health codes, landlord shall maintain and repair the roof, porches, windows, exterior walls, screens, foundations, floors, structural components, and steps, and keep the plumbing in reasonable working order. If the premises are located in a condominium, landlord and tenant acknowledge that the maintenance of the structural elements and common areas is performed by the condo association as part of the common area maintenance. Landlord shall assure that the association complies with applicable building, housing, and health codes relating to the premises. If there are no applicable building, housing, or health codes, landlord shall assure that the association maintains and repairs the roof, porches, windows, exterior windows, screens, foundations, floors, structural components, and steps. It says the landlord will be responsible for all the maintenance of any items listed above for which the association is not responsible for. So if it's a townhouse and the tenant is renting it, sometimes the roof may be the responsibility of the landlord and not the association. If that's the case, they should be aware of that, and the landlord should be aware of that to know that if there's a roof leak, they must fix it. So be cognitive of that. Elective maintenance. Fill in the blank spaces below in the section with landlord or tenant to show who will take care of the items noted. So we have a bunch of items noted down here: smoke detectors, exterminations of rats, mice, roaches, ants, wood destroying organisms, and bed bugs, locks and keys, clean and safe condition of outside areas, garbage removal, running water, hot water, lawn, heat, air conditioning, furniture, appliances, fixtures, pool, heating and air conditioning filters. They added that in there, and anything where it says other, if you want to add anything else that's particular to that place. So you could just click landlord or tenant, whatever you guys are negotiating in regards to. Sometimes, you know, hot water is part of the association, so you would just say landlord. If the tenant has to, same with like the heat, air conditioning. Air conditioning, it doesn't mean that it's the actual air conditioning unit itself. That is a tenant's responsibility. Air conditioning, you would definitely want to put landlord there. It already states down here that it's the filters, so you could make that the tenant's responsibility to change those out every, month or couple months or whatever you guys negotiate. Down here, it says tenant's responsibility, if any indicated above, shall not include major maintenance or major replacement of equipment. So basically stating that air conditioning is the landlord. Even if it was the tenant that you put here, it's stating here that major repairs is the responsibility of the landlord. Landlord should be responsible for major maintenance and major replacement of equipment, except for equipment for which the tenant has accepted responsibility for maintenance or major replacement in the previous paragraph. So major maintenance or major replacement means a repair or replacement cost of more than, you could put $100, $150, whatever is negotiated on. So anything that pertains to all of this here, if it's under $150, that tenant should be aware that it's their responsibility to cover up to that amount. Anything over that, the landlord should be called and some professional should come out and take a look at it. We all live here in the state of Florida, and we realize that termites, pest control is a thing here. So it says here that tenants should be required to vacate the premises on 7 days written notice if necessary for extermination pursuant to this subparagraph. When vacation on the premises is required for extermination, landlord shall not be liable for damages, but shall abate the rent. So your rent payment for those 7 days or however long that time takes, the landlord is stating that they're going to be abating that rent for the time period that they're not going to be in the unit. But it also states that the landlord should not be liable for any damages. So be very cautious of that. If there's any valuables or any of that home, this tenant should be taking it with them. And then goes into more in regards to that. Utilities, tenant shall pay all charges for hookups, connections, and deposits for providing all utilities and utility services to the premises during the lease term, except for, you can list anything here which the landlord agrees to provide at landlord's expense. So if there's cable with the unit, water, sewer, trash, anything like that that comes with the condo, you can put that information in there. So like specifically any utilities provided by the landlord, like it says, water, sewer, oil, gas, electricity, telephone, garbage removal, etc. Service members, if the tenant is a member of the United States Armed Forces on active duty or state active duty, or a member of the Florida National Guard or United States Reserve Forces, the tenant has the right to terminate the lease as provided in section 83.682 Florida statutes, the provisions of which can be found in the attachment. So the landlord should be well aware that if this is somebody that isn't on active duty or any one of these categories here, the landlord should be aware that that lease could be terminated. They have the right to do so. Landlord and receive security deposits, etc. back unless there's any damage to the property. Landlord's access to premises. Landlord or landlord's agent may enter the premises in the following circumstances at any time for the protection or preservation of the premise. After reasonable notice to tenant at reasonable times for the purpose of repairing the premises. To inspect the premises, make necessary or agreed upon repairs, decorations, alterations, or improvements, supply agreed services, or exhibit the premises to prospective or actual purchasers, mortgagees, tenants, workers, or contractors under the following circumstances. So if your landlord is getting ready to list the place by any means, they have to follow these guidelines in order to show the place. With the tenant's consent, either a case of an emergency, with tenant's unreasonable withholds consent, if tenant is absent from the premises for a period of at least 1/2 of a rental installment period. So Rental installment period is typically 30 days. So if they're not there for over 15 days, then that landlord has the right to be able to go in there. Prohibited acts by the landlord. Landlord is prohibited from taking certain actions as described in 83.67 Florida. So you want to make sure that you are aware of what 83.67 is in this Tenant Landlord Act below here. Casualty damage, defaults and remedies, we won't go into any of this. Assignments and subleasing, unless the box is checked, tenant may not assign the lease or sublease. So just be very cautious that the tenant is aware that they cannot sublease a unit or a room out or anything like that without that landlord's permission. So we'll just keep going down here. This is a very important page here. I get a lot of questions, Jonathan, and I get a lot of questions in regards to this page. So we're going to go over this one a little bit more thoroughly than any other page here. Approval contingency of a condo association or homeowners association. If applicable, the lease is conditioned upon approval of tenant by the association that governs the premises. If application fee required by the association shall be paid by, you'll check off the landlord or the tenant, whoever is going to be paying for the application fee. Majority of the time, it's always the tenant. If such approval is not obtained prior to commencement of the lease term, so for example, if you had the lease term to start here on September 1st, and they have not been approved by the association yet, either party may terminate the lease by written notice to the other given at any time prior to approval by the association. And if the lease is terminated, tenant shall receive and return the deposits specified in Article 5, if made. If the lease is not terminated, rent shall abate until the approval is obtained by the association. So if the tenant does not back out, or the landlord does not back out before association approval and give written notice, and they continue to keep going forward after September 1st, what happens is that rent from September 1st until September, let's say they get approval on the 10th, it's abating. The tenant's not paying for that rent, but that lease is still in place now. That lease has started September 1st, but they have not approval to move in. So the rent is abating. So if they get approval on the 10th, after the fact, then they have the right to move in after the approval and the lease will commence as forward. If you have any questions in regards to that, make sure that you contact Jonathan or I, and we can explain that to you a little further, but I just want to make that noticeable. Down here, it'll say landlord or tenant shall pay the security deposit required by the association. When you're renting in a homeowners association, condo association, sometimes these associations have their own security deposits. So the landlord will have a security deposit and the association will have another security deposit. You always, as a real estate agent, want to ask that association or ask the landlord if there is another security deposit, because it'll be first, last, and basically 2 security deposits or whatever that amount that association requires as a security deposit. So you're going to be checking off who's going to be paying that security deposit. Renewals and extensions. The lease can be renewed or extended only by a written agreement signed by the landlord and tenant, but in no event may the total lease term exceed 1 year. A new lease is required for each year. So if the year is almost up, then you have to do a new lease in order to extend or renew a lease for another year. Lead-based paint. It says here, check and complete if the dwelling was built before January 1st, 1978. If the property was built January 1st, 1978, you would not have to do this lead-based paint portion of it. But if it was December 31st, 1977, you would have to do it. So it says lead-based paint warning. Housing built before 1978, it goes into about the hazards in regards to it. I want to make you aware that this is the lessors, the landlord section here. You have a section A and you have a section B. Section A has 2 spots here that you must check off, one or the other. So AI states that there's known lead-based paint and or lead-based paint hazards are present in the housing. If the landlord is knowledgeable of lead-based paint, they would check that one off, and then they would put an explanation here of whatever the reason is. If they are unaware of any lead-based paint, they would check off B. So A, initial, check off B. Lessor has no knowledge of lead-based paint and or lead-based paint hazards in the house. Then you have section B. Section B has section BI, or basically section B1 and B2, the Roman numerals. So B1, it says here the lessor has provided the lessee with all the available records. Well, if there's no lead-based paint or the owner has no knowledge of it, B1 doesn't apply to them. B2, it states here, lessor has no reports or records pertaining to the lead-based paint. So they would initial B, and they would check off section 2 or B2. So A2, B2 would be selected if they don't have any knowledge. Now the tenants. The tenants has 2 sections right here that they need to initial. The lessee has received copies of all information above. If there's no copies, great, initial that they're stating that they've received anything, if anything, that they've got it. Section D here, by law, real estate agents must provide to the tenant the lead-based paint pamphlet called Protect Your Family from Lead in the Home. This must be initialed. Location compliance department will kick it back if this is not initialed by the tenant. And make sure you are providing the lead-based paint pamphlet, the 14-page pamphlet to them. You can email it to them, and the email will be as an acknowledgement, but just make sure you do that. Agent's acknowledgement. Agent has informed the lessor or of the lessor's obligations under 42, blah, 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 and is aware of his or her responsibilities. What does this mean when you guys initial this? Well, this means that you have provided the landlord the complying with the lead-based paint form. It's a 2-page form that when you take a listing and the property is built before 1978, that you are giving them to acknowledge the landlord's responsibilities. So you're providing those responsibilities in writing to let the landlord know what their responsibilities are. So by the listing agent initialing E, it's stating that they've given that complying with lead-based paint form to the landlord to let them know about their responsibilities. So there's actually a form that you need to provide the landlord in order to be able to initial this. So make sure you're giving out that form and make sure you're initialing this. Certificate of accuracy. So you have the landlord, the tenants signing here. If there's 2 real estate agents, you'll both sign here. And then this is all just kind of miscellaneous stuff through here. Attorney's fees. Time is of the essence on this form. The lease should be a binding upon and for the benefit of the heirs, personal representative, successors, and permitted assigns of landlords. So keep this in mind as well, that if someone passes away, this lease is binding on their heirs, personal representatives, successors, and etc. So once a homeowner or a landlord passes away, they can't, it doesn't mean that the lease is just completely terminated because there's no homeowner there anymore. Probate will have to go through, and then the heirs or personal representative will have to see the lease out until it expires. The agreements contained in the lease set forth, understanding the parties may not be changed or terminated orally. Everything is done in writing in real estate. Release and cancellations must be signed by both parties. We have it up in the paperless pipeline reference tab. You cannot use a real estate sales release and cancellation for a lease termination. It doesn't work. The boxes do not match up to the lease whatsoever. So inside the reference tab under the rental forms, there is a release and cancellation in there that you must use with the proper verbiage to be able to release out of a contract to lease or out of a lease. So make sure you're using the right form. I won't go into any more in regards to this. It's just radon gas, etc. Tenant's personal property. Now, if the tenant passes away and it's a single tenant in there, what happens to their furniture and all of their belongings? So this here, if they check this box off, it says tenant must initial in this box for the following provision to apply. By signing this rental agreement, the tenant agrees that upon surrender, abandonment, or recovery of possession of the dwelling, or due to death of the last remaining tenant, as provided by Chapter 83 Florida statutes, the landlord shall not be liable or responsible for storage or disposition of the tenant's personal property. So by checking this box, the landlord does not have the responsibility of having to remove those items. If you have family, friends, or whatever that can come and get that information, then don't check that off. Or check that off, I'm sorry. If you don't, then, you know, obviously the landlord's going to have the responsibility of removing those items if no one else does. 2 more pages, and that's what we're going to go over here. The landlord and tenant are all going to sign right here. This section where it says this form was completed with the assistance of, this is only for the section of somebody that is an interpreter, a lawyer, or somebody that has interpreted basically this lease for them, as real estate agents cannot. So realtors will not put their information right here. You are not interpreting this lease. You are not providing any legal information or anything like that. So you guys do not put your information in there. It's only for interpreters or lawyers. It says here the copy of the current version of the Florida Residential Landlord and Tenant Act is attached. So early termination fees, there's 2 sections here. You can check this box off here where it says I agree as provided in the rental agreement to pay. You could put, if the lease is $1,200 a month, you could put $2,400 here. It says an amount that does not exceed 2 months rent. So you could put $2,400 as liquidated damage or an early termination fee if I elect to terminate the rental agreement and the landlord waives the right to seek additional rent beyond. So the landlord has to agree to the termination and the tenant is agreeing that if they're going to terminate the lease, that they're going to pay $2,400. The other section here is I do not agree to a liquidated damages or an early termination fee, and I acknowledge that the landlord may seek damages as provided by law. So you're not negotiating an early termination fee amount here. This is basically stating that if I terminate this agreement and the landlord agrees to, they are allowed to seek for damages and monetary fees and stuff like that. So typically you'll see this one checked off, or this one will be checked off more so than this one will. And then, you know, the landlord will tenant will sign here. We're not going into the Florida Residential Tenant Landlord and Tenant Act. This is for the landlord and the tenant to go through. If they need advice on it, obviously they need to seek legal counsel to go forward with it. But I highly recommend you as real estate agents just to read it, just to kind of retain some information as much as possible. There's a lot of information in there. When you are submitting this lease to location, we must have all 18 pages of this lease. Just because the lease part of it only ends at page 7, it doesn't mean we don't want them, because they have to acknowledge, the tenant and the landlord has to acknowledge all of the pages. So they must initial every single page all the way down to the bottom. You will see sections in this here where it has spots that looks like they need to be filled out. That none of this in the Landlord and Tenant Act needs to be filled out. This is just sections or written notices in here that if you were ever to need to provide it, it's kind of written in here, and you could fill that information in if you're putting it on a letterhead or something. But none of that has to be filled in. So that is the lease. Do any of you have any questions for me in regards to the lease? You can unmute yourself, put yourself in notes, put your questions in the notes, and we'll go from there. I'm gonna let's see. The chat, this is what I was looking for. Which lease version should you be used? The very latest lease, Nita, is, it says here, revised July 16, and it was approved in 2010. That is the last lease that has been revised. I've heard that there's going to be changes and a new one may come out, most likely not this year, maybe next year, but that's the latest one, so you can use that one. There's another one in there for single family homes as well, so just make sure whatever you are filling out, it applies to that. So any other questions? And like I said, if you have any questions, you can always email support@locationre.com, and we can answer any questions you may have. You can always call into the office, talk to agent support, or you can ask if it's a broker question, you can talk to Jonathan or myself as well. So, and we can answer your questions. Before filling out these leases, if you are unsure of something, you can always submit it to support@locationre for us to review. So you could submit the lease along with the MLS sheet, PDF view of the MLS sheet, so we can see what's going on, and we can help you make any corrections if need be. So support@locationre.com is your best friend when it comes to any questions, because there's quite a few of us on there that can answer as fast as we possibly can. So with that said, I'm going to give it another 30 seconds to see if you guys have any questions, and then I will bid you adieu for the rest of the day.
Thank you, Michelle.
You're welcome, Fred. Nice to hear from you.
Yep.
Glad you popped on.
Okay, thank you.
All right, guys. Well, enjoy the rest of your day. We're here if you need us, and get out there and rent and sell some properties. Take care.